All right, welcome everyone. I know we're starting right at noon, so I want to give some time for folks to trickle on in. It is a Friday, so hopefully nobody's moving too fast and able to enjoy their Friday. Thank you all for being here with us. We're excited to learn with you today. And for those of you who joined us in part one of our Snapped Up series, thank you for coming back. And for those of you who are here for your first time as part of the series, thank you for being here. It's really great to be in community with you all and to learn together. So start with some general announcements. First off, this is being recorded. Anyone who registered will receive a copy of the recording, regardless of whether or not they could make it live. And that goes for the folks who are here live. If you have to drop off early, no problem. You will get a full copy of the entire recording. So thank you for giving us any of your time and being here with us today. There is a live transcription going. So I enabled the live transcript. If you need to see that live transcript, if it's not automatically popping up, feel free to, I believe you click either live transcript or more and click show subtitles. If anyone's having an issue with this, please just let me know in the chat and I will try to troubleshoot that with you. I think my last announcement before I move into introductions is that this presentation has been approved for CLE credit. I will put that CLE code into the chat after the presentation is over. If I forget, and it looks like I'm about to sign off, please remind me in the chat. That seems to be my biggest talent, is forgetting to put the CLE code in the chat. And there is one more announcement. I lied, I'm sorry. Questions and answers. So there will be some time at the end to ask some questions and provide some answers. If you do have a question though, as you're learning, as something comes up, please feel free to put it in the chat. If there is a pause, I'll do my best to try to get it out there during the time that the topic is being covered. But nevertheless, do not worry, it will be covered. It will be brought up in the question and answer at the end, if not in the moment. So with that being said, I am going to move forward with introductions. All right, so we are here today for Snapped Up, getting up to speed on all things Snap, session 2, representing Snap clients. And today with us, we have an awesome presenter. Thank you so much for being here, Jocelyn. Jocelyn Armand is the Advocacy Director of the Health and Income Unit at Legal Services of Greater Miami. As an Advocacy Director, Jocelyn leads her unit in developing strategies for the delivery of creative, effective advocacy in the areas of education, health, public benefits, immigration, and tax. She works with unit staff attorneys on unit projects such as the LGBT Justice Project, Children's Legal Services Project, Veterans Advocacy Project, Low Income Tax Clinic, Resident Reentry Project, Homeless Legal Advocacy Project, and the Ryan White Project. Jocelyn joined Legal Services of Greater Miami as a staff attorney in 2007, immediately after earning her JD from DePaul University in Chicago, Illinois. So without further ado, and no more talking from me, I'm going to turn it over to Jocelyn. Again, Jocelyn, thank you so much for dedicating your time to teach us about this important subject.
Thank you, Alexis, and good afternoon, everyone. Thank you for joining us today. Like Alexis mentioned, this is session 2 of our Getting Up to Speed on All Things Snap series. Today, I'm going to be focusing my presentation on representing Snap clients and really how we at Legal Services tackle these clients or address these issues when clients come in with these types of cases. For those of you that didn't tune into session 1. I encourage you all to listen to that. I know Alexis can get you guys all the recording. Val Greenfield and Cindy Huddleston did a great job of giving an overview on the SNAP program and the application process. So I encourage you all to listen to that if you haven't already. So like I mentioned today, we're going to be focusing more on appeals and how to help individuals that come to our offices with issues, with SNAP related issues. I'm going to do a very brief overview of the application process, just because I did want to highlight certain things that are related to the application process. It helps us lay a foundation for appeals and for assisting clients as they come into our offices. We're gonna talk a little bit about notice requirement and the right to hearing. And then I'm gonna go into how we tackle these cases and what are the strategies that we take into consideration when we're looking at these cases. We'll talk about the appeal process and what that looks like. And then of course, I will try to answer your questions at the end of the presentation. Like Alexis mentioned, please, I encourage you to drop those into the Q&A or into the chat box as they come up. And if I need to pause, I'll do that. But I do have a lot of stuff to cover. And so I just want to make sure that I get through all of it. So starting off with the application process. In my mind, the easiest way for me to break this down is into 3 different phases. Step 1 or phase 1 is the application part, right? Where our clients are completing these applications and submitting them and getting them to DCF. The second phase or the second step for me is really the processing, where DCF is taking all the information that was provided to them, processing that information, and then issuing a determination, which I categorize into phase 3 or step 3 of the application process. And I'm going to break down these different phases and these 3 different steps and highlight some things that I think are really critical for us to keep in mind. Like I did mention, Cindy and Val did a really more thorough overview of the application process. So if you want to get more information on that and become a little more familiar with that, please tune into session 1. So let's start with step 1 or phase 1 of the application process, which is completing the application. So there's 3 ways that an applicant can submit an application for benefits online on the DCF website, and that is the link. By visiting a community partner site, and that is a link to where you can search for community partners, depending on where the client resides or is located. And then of course you can print an application and mail and fax it in to the Department of Children and Families. I wanted to highlight that for purposes of an application for SNAP benefits, the application just needs to contain have the client's name, address, and signature. And this is really important, particularly more so when clients are mailing or faxing in applications. Many times clients don't have the complete information on their applications or maybe missing information. And so it's important for us to keep in mind that as long as the application has a name, address, and signature, DCF does need to process that application. I also wanted to highlight that the Department of Children and Families has ADA coordinators on staff. And these individuals are supposed to, or are there to help accommodate our clients if they're unable to submit online applications, visit a community partner site, or submit applications by mail or fax. And I'll give you 2 examples that recently came into our office not too long ago. We had 2 separate clients. Both of them were bedbound, were unable, had no access to computers, were unable to complete an online application, could not get out of their homes to visit a partner site, and did not have the ability to complete these applications. We worked with the ADA coordinators. In one case, we had DCF come out and do a home visit for that client to obtain the application. And in another one, they accepted the application over the phone. So these are DCF, staff members. They're on staff, and they are supposed to assist with complying with the ADA and accommodating our clients. So once a client completes the application, submits it to DCF, we move on to phase 2 of the application process, which is the processing of the application. I wanted to highlight here that the application date is the date that DCF receives the application. And the reason why I want to highlight that, because it's particularly important, especially for clients that are mailing and or faxing applications. Many times clients think that the day that they signed or put their name on the application is the application date. And that's not accurate. It's the date that DCF receives the application. And that's also important for us as advocates, especially when we're trying to figure out retroactive benefits and how far back DCF has to award benefits in cases where we're trying to get back benefits paid. So application date that the application is received by the Department of Children and Families. Now, the DCF has up to 30 days to issue a determination on an application unless the households or the client qualifies for expedited processing, in which the time is 7 days. Now, the TCF program policy manual has an entire section on expedited processing. I am going to provide you all with that link at the end of the slide, but I did want to highlight the 3 categories. It's important to keep those in mind. So if you have a client or a household whose gross income is less than $150 and they have less than $100 in liquid assets, they would be eligible for expedited processing. Households where the monthly gross income and liquid assets are less than the rent or mortgage and the utility allowance allotted by the Department of Children and Families are also eligible for expedited processing. And then for individuals that are migrant or seasonal farm workers, if they classify as destitute as defined by the Department of Children and Families, they will also be eligible for expedited processing. The definition of destitute has to do with the worker's assets and their income, their source of income, and when they're going to be receiving their next wage or income payment. So this is also the phase or the step where interviews are going to be conducted if necessary, and where DCF is going to ask our clients for additional information. DCF interviews are conducted over the phone, but I also wanted to make sure that you all knew and that we highlighted that if necessary, we can ask for home visits for our clients, and we could also request that these interviews take place after DCF working hours. Those are requests that we would, I recommend you doing either by email or by fax or however the case may be, because we do want to make sure we document those requests, but they are options for our clients, and there's something that we can request. As far as providing additional information, this usually looks like requests for income verification, maybe immigration eligibility if our clients need to provide that ID verification. And another highlight that I want to mention, or which may seem like common sense, is that we want to make sure that we are advising our clients that they document their attempts as much as possible to either submit requests for information or complete their interviews. It is not uncommon, and I'm sure for those of you that are listening in that do this work as well, to have clients come in with denials because they didn't sit for an interview, and so or attend their interview. And so as much as we can educate our client population to when they are submitting applications and when they are trying to comply with these requests, they document their attempts, maybe keep a log, write down notes. That is very helpful, especially as we prepare for an appeal, right? And as we put on our case for an appeal. I understand it's not always possible, but it's definitely something that we want to encourage them and advise them to do. So once the application is submitted to DCF, it gets processed. DCF goes on to issue what's called an eligibility determination. And don't worry about stressing your eyes too much. I'm going to blow this up on the next screen and we'll be able to see the notice a little bit better. But I did want to give a little bit of a snapshot of what a notice of case action or a DCF determination looks like. So like I mentioned, unless the household qualifies for expedited processing, these determinations are going to come 30 days from the date, usually up to 30 days from the date that the application is received. Now, the notice requirement we pull from Florida Admin Code Rule 65 2.0431, and that says that every applicant or recipient should be informed when there is an action on his and her claim and that they have the right to a hearing. Now, there are exceptions laid out in the rule. The more typical ones are that deal with SNAP benefits, of course, is mass changes to the program. So there's an increase, program wide, or if DCF believes that all the household members have passed away or have died, then they won't trigger a notice. But outside of that, for any action on a claim, DCF should issue or is supposed to issue a notice of case action. Now, it's really important for us to try to figure out when we're representing clients or when we're talking to clients, if clients have opted for mail or electronic notices. And this is important because if they've opted for electronic notices, they're not going to get a mail notification. And if they've opted for mail notices, they're not going to get an electronic notification. Now, for those clients that have opted for electronic notices, the way that it's supposed to work in a perfect world is that clients are supposed to get, or applicants are supposed to get, an email whenever there is a determination or a change uploaded to the DCF Access portal, right? I cannot tell you how many times that either does not happen or our clients don't get that. So when we have a client that has opted for electronic notice, we want to make sure that we encourage them to check their access portal continuously for notice of case actions. Because whether it's that it goes to spam or whether the system doesn't generate it or whatever the case may be, I think 8 out of 10 times our clients don't get a notice saying, hey, there's something new in your DCF access portal. So, just as a practitioner's tip, if you're working with these clients, really encourage them to check their portal, on a regular basis, or particularly if they're waiting for a new determination from an application. So let's go briefly and review the eligibility determination or a notice of case action. Blow this up a little bit. And I'll say that I tried my very, very best to make this as legible as possible. So I apologize if my attempt failed, but I really just wanted to give everybody, dissect the notice a little bit. So upper left-hand corner, you're going to see the date of the notice. Middle section underneath notice of case action, you're going to see the client's case number. Now that's going to be really important when you are either communicating with DCF or whether it's over the phone or by email or however the case may be. That's going to be their reference number and how they're going to be able to keep track of the case. Upper section of the notice, obviously client's information, name, mailing address. In this case, this is a client that received paper notices, but even if the notice gets uploaded to the portal, the notice will look like this, right? It'll get uploaded, it'll be a PDF that you download and it'll look exactly like this. The notices are titled Notice of Case Action. That sometimes could be a little bit confusing for clients because it's not, titled Decision or Determination. They are all titled Notice of Case Action. In the middle section of the notice, you will see the substance of the meat and potatoes, right, of the notice, which is essentially, what the decision was. Here you see an application for benefits that was approved. Underneath name, this is the client's name in this case. This client was a household of 1. However, I will say that if you have a household of multiple members, more than 1, each household member will be listed there. And then next to that name, there will be a determination as to whether or not that particular person is eligible for the benefits or not eligible for benefits. There definitely are households where certain members are eligible for benefits and certain members may not be. And then, of course, you see in this case that the individual was approved and the time period of that approval as well as the amount. So here, this client got approved for $20 in SNAP benefits. Now, for those of you that practice in this area and are familiar with these notices, you know that sometimes these can be very lengthy. DCF, Department of Children and Families, processes applications for multiple benefit programs, not just food assistance. And so in a case where maybe your client applied for food assistance, SNAP, and food assistance is what they refer to as SNAP, right? And maybe Medicaid, all of those benefit programs and those determinations are usually lumped into one notice. And the reason I want to say that is because when you are reviewing these notices, please make sure that you are reviewing the entire notice. You want to make sure that there's not any other benefit programs that maybe you need to trigger an appeal or the decision may be correct or incorrect, whatever the case may be, but you really want to make sure that you are reviewing a complete notice. Sometimes these notices can get very, very lengthy. We've seen them 5-6 pages. So just be cognizant that it's really important to review an entire notice. And then usually, or not usually, always at the end of the notice, buried all the way at the end is our client's appeals rights, right? And that is where DCF is letting the client know that they have a right to ask for a hearing before a state hearing officer, providing them timelines for doing that and instructions on how they can do that. And again, I'm gonna apologize for my failed attempt to making these legible for you all. But I just really wanted to point out where you will find the appeal instructions and where you could find that language. All right, so now let's talk about notice requirements and and hearing requirements. And I'll stop a second. Alexis, is there any questions so far that you think I should answer?
Yeah, thank you so much for giving me the opportunity to ask a question in the middle. We did get a question through the Q&A, and that question is, can a client get access to the portal to see the documents and notices, even if they opted for us mail notification?
Yes, they can, but they do have to set up an online DCF account, register for an account, and then they can absolutely access those documents. And for those clients that have the ability to do that, I would strongly encourage you to encourage your clients to do that. Set up a DCF portal account, and even if they prefer the mail notices. But that's a great question, and yes, they absolutely can.
Awesome. That's the only one that came in.
All right, great. So let's talk a little bit about notice requirements and right to hearing. So we talked a little bit about the notice requirement, right? And when DCF has to issue a notice, and that was from Admin Code Rule 65 2.0431. We reviewed that, which basically says that when there's an action on the claim, the individual has a right to know and has the right to know that they can request a hearing. Now, separate and apart from that, there is a right to a hearing, and that comes from Florida Admin Code Rule 65 2.042. And that essentially says that the department, so DCF, must provide notice of an opportunity for a hearing to any applicant or recipient when there's an action, intended action, or failure to act that would adversely affect the households or the individual's eligibility for financial assistance. And so why is that important? Because sometimes it's not uncommon for a client to come in without a notice when they have experienced an adverse action. How do we see that? Client comes in and they say, I have no idea why, I never got any notice, I've not received anything, and my food stamps this month were $50 instead of $200, or $30 instead of $75, whatever the case may be. That is an action that took place, right? And so even though the client does not have a physical notice explaining the action or letting them know of the action, and that's even, maybe DCF did send it and it got lost in the mail, whatever the case may be, in that instance, the client still has a right to a hearing because there was an action that took place by the department, right? So that's why right to hearing goes hand in hand with notice, because no notice, no problem. Now, there's timelines, and requirements as to when you need to submit an appeal, and we'll talk about that soon. But I want to make sure that you all know that a client coming into your office without a notice does not mean, oh, sorry, no notice. We have no recourse, right? We have no way to file a request for hearing or an appeal. So want to make sure that we all know that's an option. This also comes into play where assistance or services are delayed, or where there's an omission, like the DCF has not acted on an application. So we talked about how 30 days, right, is when they should issue a notice. We have, or a determination. We have clients that come in many times and say, I applied, it's been 60 days, I haven't heard anything. And so in the event, let's just say that DCF just sat on an application, there is a right to a hearing in that case as well. Intended action is a little bit trickier when it comes to the right to hearing, because usually intended actions, the client would know whether it's by a notice, but maybe not. Maybe DCF called them and said, hey, we're going to be reducing your benefits as of next month. And that could, be an intended action. So just keep in mind that, clients do have a right to hearing. They have a right to their notice, but they also have a right to hearing, even if they don't have that physical notice in front of them, or can't access the notice for whatever reason. All right, so now let's kind of shift gears a little bit and let's start moving on to, appeal issues. What are some of the cases that commonly come into our office? What are some of the things that we see, and how do we tackle these cases? How do we investigate them? So by no means is this encompassing list of what we see. I would say that this is, what we most commonly see that comes into our office. But we've seen things really outside of this list as well. So incorrect benefit amounts, common, individuals think that they should be receiving more, maybe the maximum amount, and they've been awarded less. Delayed benefits. It's not uncommon for clients to come in and say, I applied for food stamps and I haven't heard back. Terminations, right? So somebody that was receiving food stamps and now they're being terminated from the program, the benefits are being stopped. Straight out denials. So applicants that apply and DCF tells them, no, you're not eligible for benefits. And that could be for a variety of different reasons. Improper sanctions, some common ones that we see, are related to work registration. If they're ABODs or able-bodied individuals without dependents. And I know that Cindy and Val will probably get into much more detail about that in our upcoming sessions. Overpayments, right? Individuals that the department is alleging were paid benefits when maybe they weren't eligible to receive them. And so these are, again, not an extensive list of everything that we see that comes into the office, but these are some of the more common issues that we see. And anybody that comes into this in our office with any of these issues or reflecting that they might have one of these issues would trigger what we call ATI, right? Or accept to investigate in our office is when we start doing a little bit of a deeper dive to see exactly what it is that is happening in the case of this individual and what's happening with their benefits. So how do we tackle these cases and what exactly is it that we're doing when they come in? I'm going to sound like your typical lawyer when I say case by every case is different, right? And we really look at these case by case basis. But there is, I think, a general roadmap that we at Legal Services follow when investigating and looking into these cases. And I can't stress the importance of intake. And when you're doing your initial intake, because that's really honestly where this all starts, especially when there is a case that deadlines are quickly approaching. And so client intake is really going to be a place where you're going to want to focus on what questions you're going to ask and what you want to look at. So as far as strategies, I think we could break down our strategies into three main strategies. And these are not leveled in any particular order. It's just the way that the PowerPoint resulted. So I don't want you to think that appeal goes first and then caseworker and client. It's just the three strategies. I'm going to focus today on appeal and caseworker contact because that is really when we're talking about representing clients at a hearing and doing appeals, that's really where those strategies come into place. But I do want to briefly talk about client counsel. Client counsel sometimes is a strategy or is the strategy that we use when DCF gets it right. And although, DCF messes up, sometimes they get it right. And sometimes the determination that the client brings in is correct. And so that's an opportunity for us to counsel the client in explaining to them why the notice is correct, explaining to them how benefits are calculated, explaining to them what could potentially in the future, make them eligible, whether it's, income or whether it's, complying with child support enforcement, whatever the case may be. It's our opportunity to give our clients counsel and advice on how, what makes them eligible or not eligible, and as well as maximizing benefits, right? And that's something that Val and Cindy are going to talk about in the upcoming sessions, which I'll put in another plug for. Those are coming up in the next couple of months. So client counsel is a strategy that comes into play, and it's really when we're out advising our clients and counseling our clients. This could also come into play when a client comes in and says, I lost my job, I'm having issues paying my bills, feeding my family. And then we're counseling to say, hey, there's a SNAP program. This is eligibility guidelines. This is how you were to apply. These are, some things that you could do if you're having difficulty applying, and then counsel them on, what to do to document interviews, what to do to document, the submission of information. So client counsel is definitely a strategy, and it's something that sometimes we do right off the bat because, like I said, sometimes DCF does get it right. Caseworker contact and filing an appeal or request for fair hearing, obviously that is more, when we review the case and we really realize that, DCF got it wrong. And so that's really why we're here today. So I want to break down at client intake, what are the steps that we are following? What are we doing? And now I like, you know, Alexis said, I started in legal services in 2007. So I know that this is not always possible. So I'm going to lay that out there. I get it. But if there's a goal or if there's something that we really, really try to capture at that initial client interview, is these three, I want to say basic, but they're not basic things, right? So first of all, you're going to want to determine what type of case you're dealing with. And by type of case, I mean what type of applicant or recipient. Is this somebody that has filed a new application? Is this an initial application for benefits? Or is this a current recipient of SNAP benefits? And the reason why that is important is because if you have a client in front of you that is a current recipient and the Department of Children and Families is reducing or terminating benefits, that individual does have the option of receiving continued assistance, or what we've called aid pending for a really long time, where their benefits can remain at the current level until the resolution of their appeal, right? And that's really important because that is not available to new applicants or to initial applicants, but it is an option for current recipients. And so the first thing right off the cuff that we're trying to figure out is what type of client are we dealing with? And the reason why that's important is because appeal deadlines are going to vary depending on that, right? Because if you do have a current recipient that is having, you know, is being affected by an adverse action and you want benefits to continue, that request for appeal has to be put in a little bit earlier. And we're going to talk about time limits in the next slide. So once we know what type of client this is, what type of case that we're dealing with, the next thing we're going to look at is what are the relevant dates, right? What is the determination date on that notice if the client has it? If the client doesn't have it, can we help the client get it, you know, right then and right there? Maybe that's logging into the portal for them, you know, or helping them, you know, download that. And if they don't have the determination, right? If this is a client that comes in and says, I have no idea what happened, but this month I only got, you know, $40. What is the date of the action? When did that take place? And that's going to be really important because we want to make sure that we don't miss appeal deadlines and that we are, you know, we have that calendared and we have that in our case files. So we know when we need to file an appeal if that's what we need to do. And then, like I said, with the continued assistance, again, really important to look at those relevant dates to make sure that if our client does want continued assistance, that we make sure that we get that, we're able to get that for our clients. And then we're looking at the issue, right? Like, is this a denial? Is this a reduction? Is this a discrepancy in the amount of benefits? Is this a sanction? Is this an overpayment? Like, what is it that's going on here? And again, that's going to help not only as you prepare for a potential hearing, but again, it's going to help you as you, you know, engage in what your representation strategy is going to be. So if at all possible, to the extent that it's possible, these are the things that you're going to want to try to get right at client intake, right? These are the three kind of takeaways that you're going to want to be able to have in your file or have jotted down right before, as you start investigating these cases or looking into these cases. So let's talk about time limits. So for individuals that are current benefit recipients where there is an adverse action, where the benefits are maybe either being reduced or terminated, benefits can remain at the same level, okay? And this is straight from the DCF notice. If you request a hearing or if you ask for a hearing by the end of the last day of the month prior to the effective date of the adverse action. And I know that sounds a little complicated, but we'll break it down in a second. But essentially, before the change is going to take place, the month before, last day of the month, if you request your hearing by that date, benefits can remain the same. Very, very important. You must request that benefits remain the same. If you file the appeal, even if it's during that timeline and you don't request that the benefits remain the same, DCF is not going to automatically not, you know, continue to issue them. Okay. So make sure that if this is something that your client wants, that when you help them, you know, submit the hearing request or when you're submitting the hearing request, that you are clear on, hey, we want benefits continued. Okay. That's important to talk to your client about, because in the event that they were to lose at the fair hearing, in the event that, you know, DCF was right, they may be on the hook for an overpayment. They may have to pay that back. So you just want to make sure that you talk to your client about that and make sure that you're on the same page as to whether or not they want that. Now, for new applicants or for individuals that are not current recipients, the deadline to appeal is 90 days from the mailing date at the top of the notice. And time limits are, they are laid out in Florida Admin Code Rule 65 2.046. You can get obviously much more detail on that there, but 90 days from the mailing date on the top of the notice is when you can file an appeal. Now, the 90 days to file an appeal also applies to continued benefits. So like, let's say your client doesn't want those continued benefits, you have 90 days to submit your appeal. So it's not that you know, if it's a current recipient, you have to get it in, you know, within the end of the month. It's that you have to do that if they want their benefits to continue at the same benefit level. All right, so no training or no webinar is one without a hypothetical. So today we are going to talk about Mary. So Mary is seeking assistance with a reduction in SNAP benefits. Her benefits have been reduced from $200 to $50. And I'm going to just let you all either drop your answers in the chat or write them down, or, you know, think about them in your minds and check yourself. But I really wanted to apply some of the things that we talked about to work it through. So this is Mary. She comes into your office. She's getting a reduction in SNAP benefits. And this is obviously an adverse action. So the first thing we're going to look is, could Mary be eligible for continued benefits at the same level? Is Mary one of those recipients that can opt for continued benefits? And so I'll give you all a minute to think about that and to determine that. And so I'm hoping that, you know, you've made a determination already. And the answer to that question is yes, right? So Mary is a current recipient. She was receiving, you know, SNAP benefits. She was receiving them at $200. This is an adverse action that's reducing them. And because she's a current recipient, if timely appealed, right, her benefits can continue at the same level. So for those of you that thought yes, very good job. Mary's notice, she brought it in, is dated July 12th. And the notice informs Mary that her benefit reduction will be effective August 1st. So the next thing we want to figure out is, all right, so if Mary wants her benefits to continue, by when do we need to have an appeal filed, right? When is it that we need to get that into the department? And so I'll remind you all that the notice tells Mary that if she asks for a hearing by the end of the last day of the month prior to the effective date of the adverse action, her benefits can continue. So give you guys a few seconds to jot that down or put it in the chat or however it is that you want to volunteer your answers. And hopefully you decided or you determined that that deadline is going to be July 31st. And so let's walk through that. So let's assume that it's today. So today is July 22nd, right? She comes into your office today. The notice says July 12th. The last day of the month, the effective date is August 1st. And so the last day of the month prior to, you know, that August 1st effective date would be July 31st. And so that is the deadline, or that's when Mary has to get her appeal notice in to get continued benefits. And of course, specifying, right, that she wants those benefits continued. Now, you discuss the option of continued benefits with Mary, and she just really tells you, you know, I'd rather not opt for continued benefits. It makes me nervous if we lose, and I just don't want to have to deal with that. So I'll just live with whatever until we figure all of this out. And you really think Mary has a great case, and you're definitely going to represent her. You've pretty much determined that we're going to go forward with this. And so what are you going to calendar as Mary's SNAP appeal deadline? Like, when is it that you need to make sure that you have in your calendar the day that this is due? And so I will remind you that the rule says that you have 90 days from the mailing date at the top of the notice to file this appeal. And so I use date calculator. For those of you that don't use that, I definitely encourage you all to use it. I don't know if you all have it in front of you right now and you're working on that, but that 90-day deadline would be October 10th, right? And so for all of you that said, oh, sometimes in October, that's right. So Mary has to have her appeal in by the 10th, but if she wants continued benefits, she would have to have it in by the 31st. And this is really important, right? Because this is really going to shape your strategies and like how you are going to tackle these cases. If Mary would have come in to your office, you know, on October 9th, you know, assuming that, you know, your office was open that day, right? Your strategy really is going to have to be filing a request for hearing, right? There is no real time to do anything other than that. I mean, assuming, of course, you think there's merit to this case, right? There's really no time to do anything other than that, right? If Mary comes in and says to you, you know, it's July, you know, 29th or July 30th, you know, assuming that's the day your office is open, and she wants continued benefits, really your strategy option is the same. You have to file that appeal. You have to get that in. There's not a lot of time to do anything else other than that. But if she comes in today, July 22nd, and you have until July 31st to submit that hearing, then you could engage in the other strategy that I mentioned, which is caseworker contacts. And we'll talk a little bit about that in a second. But this is why it's so important to look at the type of client that you have in front of you and what the deadlines are. Because sometimes, regardless of whether or not you think you might be able to resolve an issue through case manager, you know, or caseworker contacts, you really have no choice and you have to go straight to the hearing. So this is really why I stress, you know, try to figure out as soon as possible what type of recipient this is, what type of applicant is, and what are those appeal deadlines, because that's really going to dictate strategy. Alexis, is there anything you think maybe I should answer right now? Before I keep on chugging along.
No, I'll ask. There's one question I'll ask it towards the end. I want to sincerely apologize. The chat was disabled for some reason all throughout your hypothetical. So it's not that people didn't probably want to.
Honestly, I can't even see it. So I'm going to pretend that everybody got it all right. And
yeah. So I'm very sorry, folks. The chat should be available now. I'm very, very sorry about that.
All right, so let's keep on going. So let's say, you know, Mary's in your office and you're like, you know what, I have a little bit of time to engage in caseworker contact, right? What does that look like? I'll tell you what it looks like for us at Legal Services. We have established a relationship, and it's been a relationship we've had for a really long time, that we have a direct caseworker contact at the Department of Children and Families. She's a client relations coordinator. We've had a working relationship with her for a very, very long time. And so when we have the time and we're able to engage in caseworker contact as a strategy, where we're trying to resolve the issue directly with DCF before filing a hearing, we're reaching out to our caseworker contact and we're saying, hey, we have this client, this is a case number, this is what's going on. We think, you know, DCF might have gotten it wrong. Can we talk through this? And sometimes that resolves the issue right away. I would say that I think 7 out of 10 times things get resolved through this strategy. So it's really our preferred strategy to go on. It's really what we try to do first if we can, because obviously, you know, it's beneficial for our clients and it gives them, you know, a quicker result. If you don't have that relationship, or you haven't, you know, you're new to this, you're trying to establish these relationships, you know, I gave the link to the Access Client Coordinators. They are laid out by regions. And so, you know, email them. Don't wait for a case, email them, reach out to them, introduce yourself, you know, and maybe you could start establishing those relationships. I know that for us, it's really, really helpful, and it really helps us resolve a lot of cases for our clients. There is a customer service call center. Sometimes we do have to opt for that. Sometimes, you know, we are respectful of our relationship with our DCF caseworker. So we are really reaching out to her when we think we have, you know, a meritorious case that we feel strongly about. But, you know, contacting the customer service center is always an option. If your client is in your office, if you're trying to figure out, you know, what's going on, what happened, that's always something that you can do with your client. And get some information and start getting the ball rolling on that. But, you know, sometimes it doesn't work, right? Sometimes, you know, despite our emails and despite, you know, our back and forth and despite, you know, our attempts to work it out with a caseworker, it doesn't, you know, it doesn't work out. And sometimes caseworkers could do something like, you know, approve the benefits, but then we want some retro, and then, you know, we still have an issue about that. And so, you know, to the extent that we could work it out and we could, you know, do that caseworker contact strategy, wonderful. But to the extent that we can't, then obviously we have to shift strategies and go on to that appeal strategy. Now, let's go back to Mary, right? So you contacted the DCF caseworker, you've been going back and forth, and it turns out that DCF is telling you that it's because Mary is now getting a monthly pension. And that is why the food stamp benefits have been reduced from $200 to $50. Now, let's say, because it happens sometimes, that you're talking to your client and she, let's say Mary tells us, oh, wow, Jocelyn, you know what, you're right. I did start getting that pension, but I didn't realize that that would count for income for SNAP purposes. And so I'm not saying that it would or wouldn't, depending, but I'm assuming that it does. That strategy then is going to shift from appeal fair hearing back to client counsel, right? Because now it's like, well, Mary, you are getting this income. It does count, let's just assume it does for SNAP purposes. And so, we're not going to go forward with a hearing in this case. DCF did get it right. Now that we've done some more digging and, we move on to that client counsel, right? So sometimes we go from caseworker contact to client counsel instead of appeal hearing, and that happens. And it's not super common, but it's not uncommon. Now, let's say, DCF is saying, yes, she has this pension. And Mary's just like, no, I don't. And you've done your due diligence with the client and you looked at bank statements and you've kind of, done your research and you guys have gone back and forth and you're like, yeah, she really doesn't have this pension. And, DCF is just like, look, we can't work this out. We can't fix this. Well, what are you going to do next? Right. And so you need to file your appeal. And so the Florida Admin Code Rule 652.044 lays out what the request for fair hearing requirement and the ability or the freedom to make that request. And so there's a lot of ways that a client could request an appeal, and that's because it's so important. In the rule, it says that the ability to make that request should not be limited or interfered with in any way. And so you can do that online. At this link, I provided the link. Your client or you with your client can call over the phone and just say, I disagree with my determination and I want a hearing. You could fax in a request for appeal. You can mail it in. You can send an email to the hearings office, and you could submit it any of those ways. Very different than applying, right? Applying and getting an application in is more limited, but hearing and that request is much broader, right? There is not a required form to file a hearing. The rule is very clear. It says that a request for hearing, as long as it's clear, written or oral, saying that you want a hearing, that is enough. However, there is a sample hearing form that is made available that you can use or don't have to use, but it is there and it is an option. And we'll take a look at it in a second. But again, these are all the different ways you can file an appeal. Any of these ways is appropriate and it's okay. Obviously, if your client is going to do it over the phone, you're going to want to document when you did that. And if you're going to send it by mail, I encourage you to do that with some sort of tracking so you know that it got there. But you can do it any of these ways. Now, like I said, there is no fixed form or format, but this is the appeals form that is made available. I will say that, these options. So I've been notified of the following action taken on my case, and I'm not satisfied for the following reason. That could be as simple as, reduce SNAP, I disagree. It does not have to be detailed. It does not have to have, a lot of language in there. It could be as simple as possible, as long as it's clear from that language that you want a hearing or your client wants a hearing, you're good. And you will see that there's two options right there in the middle. It says, I want my benefits continued or I do not, all right? That is the only thing that you do, remember, have to check off in the event that you want that done, okay? Or that your client wants that done. But again, no specific format. This is an option for you if you want to use it. Okay, so what's the appeal process? What happens? Your client goes into the office, you go ahead and you do this request for hearing, you submit it. Florida Admin Code Rule 652.049 says that upon the receipt of request for hearing, a supervisory review is mandated by the Department of Children and Families. Now, in our cases at Legal Services, and even though DCF is a statewide agency, all the regions kind of function a little bit different, but in our cases, as soon as we submit a client's appeal, they automatically assign it to DCF Counsel, and DCF Counsel is usually reaching out to us to say, what's going on with this case. Okay. Again, we also have very good relationships with DCF counsel. And so sometimes we'll go ahead and reach out to them. We work very well together. And so that happens. Now, there is, again, many times that DCF realizes or determines that they got it wrong. Okay. And in that case, they are supposed to let the individual know that, that DCF got it wrong. They're supposed to take immediate action, all right, to rectify it. And they're supposed to tell the client. Now, these supervisory reviews are done over the phone. So they're usually like a phone call. It's not like a formal conference with Social Security or anything that takes place like that. They're paper reviews and they reach out to you. Very, very important. DCF is going to want you to withdraw your hearing request as the sooner the better. Do not withdraw your client's hearing request unless you have a new notice that lays out the appropriate benefits, unless benefits are paid on the EBT card and your client is made whole, or until you have some sort of written stipulation filed with the hearing officer basically saying DCF got it wrong and they're going to get benefits. Okay. They are going to want you to withdraw as soon as possible. But just please be mindful of not doing that until your clients are get their benefits. Right. All right. Pre-hearing, right? Leading up to the hearing. The conduct of the hearing is laid out by Florida Admin Code Rule 65 2.057. That is where you're going to see the conduct of the hearing. Discovery is an option in these hearings. Your client must be given the opportunity to examine all the documents and records that are going to be used at their hearing at a reasonable time before the hearing. And they have the right to examine their case file, even if that's not all going to be introduced as evidence by the department. Usually, the documents that are going to be introduced by the department are attached to the notice of hearing. They usually get that out to the clients pretty soon. But I would, if you are requesting a hearing, if you filed your hearing request, I would encourage you to request that file, start looking at those documents as soon as possible. And that's going to, contain their application forms, any documents or verification that the department relied on when determining eligibility basically what they're relying on, right? What they're stemming their position from. The Florida Rules of Civil Procedure apply in the sense that you can do requests for productions if you need to, and so on and so forth. But usually in our SNAP cases, for the majority of them, once we receive the case file and we see what DCF has, that tends to be enough for us to really start laying out our case. As far as the appeal process is concerned, or the day of the hearing, again, laid out by 65 2.057, these are phone hearings. Interpreters are provided by the department. I would encourage you all to just confirm with the agency clerk that, they have that your client is going to need an interpreter because, that you definitely want that ironed out before the hearing just to prevent any delay. The standards at these hearings is de novo, which basically means that the hearing officer is going to give a fresh analysis to this case. They're going to be looking at all of this, for the first time with no deference to the agency's decision. The burden of proof is going to depend on who on the issue, right? So if this is a case where you're representing an individual who's applying for benefits and is seeking an increased benefits, the recipient, the claimant, your client will have the burden of proof. If it is an adverse action where there's a reduction or a termination, the department has a burden of proof. You could bring witnesses. You obviously could submit evidence, and you're encouraged to submit your evidence. The hearing notice will say to send in your evidence 7 days before the hearing. Obviously, we want to submit evidence as soon as possible and as early as we can get it in. But I do want to point out that you can submit evidence at any point during or before the hearing. So if you got some evidence in 7 days before and all of a sudden something comes in that's essential to your case, please note that 7 days is not the cutoff. You can introduce at the hearing or even after those 7 days. You're going to have the ability, obviously, to direct your client or any witnesses and cross-examine any DCF witnesses as well. And of course, have the ability to provide opening and closing statements during the hearing. So let's quickly prepare for Mary's hearing. And this is, again, some of the things that, I encourage you all to do as you are preparing for these hearings, especially if you're new to this area. Review the rules and consult with other advocates. There's a lot of wonderful advocates throughout the state of Florida that do this work, that have been doing this work for a really long time. So don't be shy. We have listservs, and, I think we're a great network of attorneys. And so consult with other advocates, especially with novel and different types of issues, and review the rules, right? Get as comfortable as you can with the rules. And so you're just prepared and you know what to expect. Figure out who the burden of proof lies on, right? That's going to be essential when you're getting your hearing together and gathering evidence and prepping for that. In Mary's case, I don't know if you all recall, but this was a reduction in benefits. So in Mary's case, who has the burden of proof, right? We said that if there's a reduction or a determination, that belongs to the department, and if it's a new application, it belongs to the client. In Mary's case, the burden of proof lies on the department. All right, so that's going to be really helpful as we start preparing for that hearing. You're going to want to request and examine the case file. Take a look at the documents, analyze the documents, see what DCF is using to rely on to make those determinations, okay? And start thinking about what you're going to need, if anything, right? Maybe your client is the one with the burden of proof to meet your burden. Gather and submit your evidence. Like I mentioned, you can do that up until the day of the hearing, but I will encourage you, the sooner you can get that in, the sooner you can get everything gathered, reviewed, and submitted, the better. I definitely encourage you all to get that out as soon as possible, and really only get things in on the last day or leading up to the hearing in cases where it's absolutely necessary. Confer with DCF counsel. Is there things that we agree on? We've had cases where DCF counsel says to us, we agree that your client is eligible today, but wasn't eligible on the date of application. And so really then, then what we're really kind of going back and forth on is retroactive eligibility. So is there things that you agree with? Is there something that you guys can stipulate? Can we really narrow the issues and really present what we need to present at this hearing and really focus on what's really at issue, what's really at stake? Prepare your opening and closing statements as much as possible. I personally think that that's a great way to lay out my case and to get familiar with the story of my case. So prep those, try to have at least an outline of that, know what you want to get across, know what you're trying to convey to the hearing officer and get on the record, for your client and for your case. Prepare your clients and any witnesses. This is very, very important. And that's, procedure, testimony that you're going to take, evidence that you're going to submit. Obviously, this is all very, very important to go over with your client. These are nerve-wracking situations for our clients. We all know that. This is new to some of them, and so we want to make sure they feel as comfortable as possible when they are, at these hearings. And then lastly, this is something that you would make a determination during the hearing, but do you need to make a request to leave the record open? Did something come up during the hearing? Is there something that you could provide? Did something, come up that you're like, what, I could submit that after? Can we get that in after? Feel free to request to leave the record open if it's something that you think needs to be done to help your client or to prove your case. That's something that obviously the hearing officer would have to approve, but usually they will. And if you need to do that, put that request and ask for that. Now, what happens after the hearing? You have your hearing, you take your testimony, you present all your evidence, you do your closing statement. You're not going to find out that day. The hearing officer is going to issue a written decision determining, what they decided. If your client wins, if the household wins, DCF will pay benefits within 10 calendar days, and they can pay retroactive benefits 12 months out. And then these are final on the agency, right? So they cannot appeal. Now, if the household loses, if this is something, that you don't get a favorable decision, clients will have to pay, continued benefits or aid pending. If they opted for that, the household can appeal to the District Court of Appeal within 30 days. And obviously there is a filing fee waiver if your clients are indigent. And I know that I'm already past time, so I just want to lastly get you all some resources. The DCF program policy manual goes into great detail about everything I just talked about. I have it bookmarked bookmarked. I refer to it all the time. You could find obviously the rules on the Florida Admin Code site. The DCF website is very helpful, you know, with information and fact sheets. Actually a pretty good website. I don't know if some of my other colleagues may agree, but I find it to be better than most. 7 CFR Chapter C lays out requirements for the SNAP program. And then there's an amazing SNAP calculator on floridapolicy.org that really would be essential, especially when you're counseling clients and trying to figure out whether or not clients are eligible for benefits. It is certainly a great resource. So I think all of these are really helpful and really beneficial, especially for those that might be starting out handling these cases. And then lastly, questions. Alexis, I know I'm over, so I don't, I'm sorry about that, but is there anything that I can try to answer? I don't know if I know all the answers, but I could definitely try.
Yeah, sure. Jocelyn, thank you so much. This was awesome. I think that, you know, dealing with this system, sometimes it's clear as mud, and you've clearly dealt with the system for a long time and know a lot of the ins and outs. So I think that this was a wonderful presentation. I will let folks know, since we are at one o'clock, before we get to some questions, do you have a few seconds? Do you have time, Jocelyn? Do you have?
I'm happy to stay on if you guys need.
Hopefully not too many more minutes, but I just want to tell folks that I did drop the recording to part 1 into the chat. I did drop a flyer for the training series into the chat, and I am dropping the CLE number into the chat, 6143, for folks who maybe need to drop off. If you do have to drop off and get back to work, don't worry. These questions are included in the recording, so you will receive this recording after the fact. So going up to questions, there were actually quite a few, Jocelyn. I'm going to start with the one that came into the chat. The question is, if a client via phone was told over income, sorry, let me do that again. If client via phone was told over income, but there are deductions that were not included in the application, do you have to appeal, or can you call and correct the application?
So I'll tell you from our experience, that's something that we do with a caseworker, with that caseworker contact, right? So that's when we would, you know, call our DCF caseworker and say, our client, you know, submitted this application, was missing some information, and can we update that? We have a great relationship with our DCF caseworker, and, you know, and she'll tends to do that. However, technically, what the client should do is, you know, complete a change report on the portal with the new deductions and new information, and then DCF will recalculate the benefits. You know, like I said, this might be one where if you have a DCF worker contact, you want to reach out to them, you know, and get them, you know, to help you process that. Or if not, you want to get that change report reflecting those, you know, deductions in as soon as possible.
All right. And so I'm going to go over to the Q&A, because there were a few questions in the Q&A. Quite a few questions in the Q&A. So I'm going to start with the first one. I'll start from the bottom, actually. Do you think it's better for clients to ask for mailed notices rather than an opt out for online?
You know, I think that depends on the client, right? If you have a client that has access to a computer and can easily access, you know, their portal, I prefer the online, you know, account, because I personally find it to be easier. It's easier for me to, you know, find things for my client. It's easier to get notices. But if you have a client, especially one where you're just counseling them, you know, to apply, and they don't have access to a computer, and they don't, you know, it's not readily available for them, they don't have a family member, friends, or whatever it is that can help them with that, then mailing notices are definitely, I think, the better route for that client.
Okay. Next question is, do you ever ask for an in-person or video hearing, or is that not even available ever? If you get an in-person or video Zoom instead of phone only, is it just in particular situations that DCF will grant that?
You do have your client can request an in-person hearing. I'm going to be honest, I've not done a Zoom hearing with DCF for SNAP benefits, but you can request an in-person hearing. It doesn't have to be a specific situation or a specific circumstance. You could request it. And now I will say that they will usually take longer. It depends. A lot of these hearing officers are not in Miami. They're out of Tallahassee. So also depends on, where you're located, and getting that. So you have a right to ask for one. You can ask for one, but it could definitely, delay that process.
Okay. Next question came in both in the chat and in the Q&A. How do we get on the listserv for the public benefits group?
Oh my God, that's a great question that I don't know the answer to. I've been on it for like 15 years, so I don't know, but it's something definitely that we can look into, Alexis, and we could send people the information on how to. I believe we have to send an email, and you have to get screened and then approved and get on there. So we owe you that response. I'll get that for you and provide you all that information.
Awesome. And folks, if that information doesn't go out with the 24-hour email that usually gets sent out with the CLE code and the materials, just email me. You can say, hey, remember that training where Jocelyn told us all this awesome stuff? Can you please tell me how to get on the listserv? And Jocelyn and I will follow up. And we do have something in the chat that might be helpful on this question, actually. So Valerie, who is actually one of our presenters for the rest of this training.
Thanks, Val. I was hoping. Yes.
Put into the chat, go to floridaadvocate.org and join practice for public benefits. So it's like the same where the training listserv is. So I can put that in the follow-up materials for sure. All right, let's try to power through these. If local DCF counsel contacts me after I ask for a hearing, does that count as the mandatory supervisory conference, or should we not be sticklers about that?
I mean, for us, I'm not really a stickler about that. That to me really is, DCF counsel trying to do that. Usually what happens is they, because we filed a notice of appearance, because we're the attorneys, and, the attorneys like to talk to us as attorneys, and usually they are, they're talking to their team and getting a response from their team, and then they're reaching out to us. So I consider that to be, for intensive purposes, the conference.
All right, so a few more. This is a great question. How do you counsel a client who wants you to appeal, but you think DCF was right?
Wow. I think with patience, and really just trying to explain to them that even though it may not always be what they seem to think is fair, sometimes that's the case, that's just not what the rules allow. And we try to be as clear, provide them as much documentation, like, sometimes we'll give them the chart that shows what the income limits are, or we'll print pages out of, the DCF handbook. And we always tell them that they have a right to request a hearing. I mean, they don't have to be represented. They don't have to have an attorney. They can go get a second opinion. Our clients, have the right to do it. So we try to counsel them and tell them that, we don't think that they may have the best case, and they may not get a favorable decision, but that they absolutely 100% can request a hearing. And we actually provide them the tools to be able to do that and talk them through that process. If our clients want to have a hearing, they have every right, to request that hearing and be heard, and they don't have to be represented by us, and they have that option. So, we try to dissuade them from it if we think that, it's not a good case, but if they're adamant about it, then we just tell them this is how you do it, and this is what you're going to expect, and this is, what you should try to prove, and so on and so forth.
Got it. So next question, this one is the last one, then there's one that has a few parts to it, so I'll try to read them in parts, how do the time limits for asking for a hearing work if the client never gets notice of whatever?
Right. So we will, we usually, action date, right? So when is it that the client became aware of whatever it is that happened? And that's where, we will, that's what we use as the date now, and we'll put that in the hearing. Those hearing requests might be a little bit more complicated because, if it's an untimely appeal, DCF, well, the first issue is going to be whether or not you filed a timely appeal. And so sometimes we'll explain in that hearing request, never got a notice. This is the day that the client, was made aware of the intended action. And as such, we're filing a request, as soon as they, as soon as they became aware of the action. And that's, typical of like my example, right? Client comes in, benefits were approved at 200, and all of a sudden, they've been getting $200, and now all of a sudden, the day that the SNAP gets deposited, they had no notice, and it was like $30. And so as soon as that client finds out, then they call us. That's what we'll, we start that as a deadline for that appeal.
Got it. So this one is the last one. I'm going to break it up into questions. The first question that's in here is the client responsible for updating their address and contact information?
Yes. So if your client moves or, has a change in address or phone number, yes, they are responsible for letting the department know. They can do that by filing a change report online. I believe that captures that information by contacting the Department of Children and Families as well. They could do that through the customer service center, through the change report. And if neither of those, if you can't get through or you can't do the change report, then I would, advise them to send in a fax with like their case number and just like their new information so that we have a record that they updated that information.
If the client is a current recipient, how long do the benefits maximum last if there's a reduction or adverse action or appeal from a prior grievance?
So they will last through the decision of the appeal. So when the decision is issued on the appeal of that issue.
The next question. Oh, sorry.
Right. So let's take Mary, right? So let's say Mary was receiving benefits. She files an appeal. Her hearing date, is October 1st. We end up getting a continuance, and we don't have a hearing until November. She will continue getting those benefits up until the hearing officer issues their decision.
Got it. And I'm not sure, this question came in early, so it might have been answered, but is there a SNAP contact? I'm not sure if that was something specific that was being said at the time. If it doesn't ring a bell, I can ask the other question.
Yeah, I mean, as far as, I don't know what like SNAP contact per se is, that there is a website that I provided with like the access, the customer service reps. I think that's probably maybe what they're referring to. It's on the slides. There's a link to breaking it down by region, who are I believe they're called customer service access representatives or contract specialists.
Got it. And I think, let me see if I can break this up. Is there a limit on where folks can use their benefits? Walmart, Publix, Winn-Dixie, some health plans have this too. So is there a limit where they may use this benefit?
No, as long as it's a place that is approved to receive SNAP benefits, they can use it there. I believe with the pandemic, I think they added, I believe it was like Walmart or Amazon, I think, was added on during the pandemic. I think you can't use it to pay for the delivery fees, but as long as it's a place that accepts SNAP benefits, you could use them at that place.
All right, and last question, finally. Does this adverse action have any bearing on any CMS grocery allowance that a person may also be receiving?
You know what? I don't know the answer to that question. That's something that I'd have to look into and get back, get that response back. I don't want to say yes or no either way because I'm not entirely sure. So that's something that I owe you all.
Awesome. Well, that's it. You powered through all of those questions. That was quite a few questions at the end, which I think really goes to show you how complicated this is and how many folks, really struggle to try to navigate it and do the best for their clients. So I don't know if you can see in the chat now, Jocelyn, but you're getting a lot of thank yous and great program and just thank you very much. And so before I leave it to you for last words, I just want to remind everyone that the next part of our training series is going to be August 26th. And that is also going to be at noon, going to be on Zoom. And that part of the series will discuss maximizing SNAP benefits. So I did drop into the chat a training flyer. I will also be emailing, everybody, and I'll put also those registration links in the email. The follow-up email will not come from me directly. It will come from Zoom. So folks, 24 hours from today, look through your inbox, And then you should be able to get the CLE code there, the recording there, any materials, how to join the listserv, and all the other goodies that Jocelyn has shared with us. So I know you've done a lot of speaking today. I don't know if there's any last minute thing you want to say before I close us out.
No, just thank you. Thank you all for, fighting the good fight with all of us. I know this is not always the easiest thing to do. So, hats off to all of us that are trying to make a difference in our clients' lives. If you have any questions, I'll include my contact information in the materials. Please feel free to reach out to me, brainstorm with me. I'm happy to help and share any additional resources that I may have. So thank you. I hope everybody has a wonderful weekend, and thank you for joining us and tuning in. And thank you, Alexis. We wouldn't be able to do any of this without you. So thank you very much.
It was my absolute pleasure. Thank you for doing this on a Friday. Thank you for teaching us all about this important stuff. And thank you all for joining us on a Friday. We'll see you at the next one.
That's good. Bye, everyone.